The Employees' Compensation Act 1923, as amended through Ec Amendment Act 2017. 10. Notice and claim. 1. No claim for compensation shall be entertained by a commissioner unless notice of the accident has been given in the manner hereinafter provided as soon as practicable after the happening thereof, and unless the claim is preferred before him within 2 years of the occurrence of the accident, or in case of death within 2 years from the date of death. Provided that where the accident is the contracting of a disease in respect of which the provisions of subsection 2 of section 3 are applicable, the accident shall be deemed to have occurred on the first of 8 the days during which the employee was continuously absent from work in consequence of the disablement caused by the disease. Provided further that in case of partial disablement due to the contracting of any such disease and which does not force the employee to absent himself from work, the period of 2 years shall be counted from the day the employee gives notice of the disablement to his employer. Provided further that if an employee who, having been employed in an employment for a continuous period, specified under subsection 2 of section 3 in respect of that employment, ceases to be so employed and develops symptoms of an occupational disease peculiar to that employment within 2 years of the cessation of employment, the accident shall be deemed to have occurred on the day on which the symptoms were first detected. Provided further that the want of or any defect or irregularity in a notice shall not be a bar to the entertainment of a claim. A. If the claim is preferred in respect of the death of an employee resulting from an accident which occurred on the premises of the employer, or at any place where the employee at the time of the accident was working under the control of the employer or of any person employed by him, and the employee died on such premises or at such place, or on any premises belonging to the employer, or died without having left the vicinity of the premises or place where the accident occurred, or B. If the employer or any one of several employers or any person responsible to the employer for the management of any branch of the trade or business in which the injured employee was employed had knowledge of the accident from any other source at or about the time when it occurred. Provided further that the Commissioner may entertain and decide any claim to compensation in any case notwithstanding that the notice has not been given or the claim has not been preferred in due time as provided in this subsection, if he is satisfied that the failure so to give the notice or prefer the claim, as the case may be, was due to sufficient cause. 2. Every such notice shall give the name and address of the person injured and shall state in ordinary language the cause of the injury and the date on which the accident happened, and shall be served on the employer or upon any one of several employers, or upon any person responsible to the employer for the management of any branch of the trade or business in which the injured employee was employed. 3. The state government may require that any prescribed class of employers shall maintain at their premises at which employees are employed a notice book, in the prescribed form, which shall be readily accessible at all reasonable times to any injured employee employed on the premises and to any person acting bona fide on his behalf. 4. A notice under this section may be served by delivering it at or sending it by registered post addressed to the residence or any office or place of business of the person on whom it is to be served, or, where a notice book is maintained, by entry in the notice book. 10a. Power to require from employers statements regarding fatal accidents. 1. Where a commissioner receives information from any source that an employee has died as a result of an accident arising out of and in the course of his employment, he may send by registered post a notice to the employee's employer requiring him to submit within 30 days of the service of the notice a statement, in the prescribed form, giving the circumstances attending the death of the employee, and indicating whether, in the opinion of the employer, he is or is not liable to deposit compensation on account of the death. 2. If the employer is of opinion that he is liable to deposit compensation, he shall make the deposit within 30 days of the service of the notice. 3. If the employer is of opinion that he is not liable to deposit compensation, he shall in his statement indicate the grounds on which he disclaims liability. 4. Where the employer has so disclaimed liability, the Commissioner, after such inquiry as he may think fit, may inform any of the dependents of the deceased employee that it is open to the dependents to prefer a claim for compensation, and may give them such other further information as he may think fit. 10b. Reports of fatal accidents and serious bodily injuries. 1. Where, by any law for the time being in force, notice is required to be given to any authority, by or on behalf of an employer, of any accident occurring on his premises which results in death or serious bodily injury, the person required to give the notice shall, within 7 days of the death or serious bodily injury, send a report to the Commissioner giving the circumstances attending the death or serious bodily injury. Provided that where the state government has so prescribed, the person required to give the notice may, instead of sending such report to the Commissioner, send it to the authority to whom he is required to give the notice. Explanation. Serious bodily injury means an injury which involves, or in all probability will involve, the permanent loss of the use of, or permanent injury to, any limb, or the permanent loss of or injury to the sight or hearing, or the fracture of any limb, or the enforced absence of the injured person from work for a period exceeding 20 days. 2. The state government may, by notification in the Official Gazette, extend the provisions of subsection 1 to any class of premises other than those coming within the scope of that subsection, and may, by such notification, specify the persons who shall send the report to the Commissioner. 3. Nothing in this section shall apply to factories to which the Employees State Insurance Act 1948, 34 of 1948 applies.